Your Honor, if it please the court, we're before the court this morning in the matter of the State of Ohio versus Tremont Crawford, case number 25 CR 1131. The defendant is present in the courtroom with his attorney, Mr. James Matthews. We're before the court for purposes of a change of plea in line with the plea agreement between the parties, and if it please the court, I'll put the terms of the agreement on the record at this time. The defendant, pursuant to the agreement, would plead guilty to the lesser included offense of count 1 being an attempted grand theft motor vehicle. It's a felony of the 5th degree upon the condition of that guilty plea being forthcoming after findings of guilt, and at the time of sentencing, the state would dismiss count 2, the criminal tools. The defendant would agree to voluntarily forfeit all items that were seized by the police through the investigation. There's no restitution owed in this case per the vehicle owner. The state would review the pre-sentence report prior to making a sentencing recommendation. The state expects the defendant will request community control.
Thank you. Mr. Matthews, does that sound accurate?
Yes, Your Honor.
Mr. Crawford, were you able to hear what the prosecutor and your lawyer just had to say regarding what they believe your intentions are here this morning?
Yes.
They indicated to the court they believe it's your desire to withdraw your previously entered plea of not guilty and enter plea of guilty to the lesser included charge of the indictment being attempted grand theft of a motor vehicle. That would be a felony of the 5th degree. Count 2 would get dismissed at sentencing. We would continue sentencing to a future day, however, to get some evaluations completed. Come back on a future day where there's no agreement between the parties regarding any recommendations for sentencing. Each side is free to recommend to the court whatever sentence they think is the right, fair thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor and what you want to do today?
Yes, sir.
Well, before I can accept your guilty plea, I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine those issues, I'm going to ask you a series of questions. Now, if at any point when I'm asking you these questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to speak with your lawyer so you could ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on here, all right?
Okay.
All right. Let's get started then. How old are you, sir?
18.
Are you able to read and write the English language?
Yes.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
Sometimes.
Sometimes, okay. There's going to be a point. How far have you gone to school?
12.
I can't hear you.
Just 12.
Did you graduate?
No.
Are you in 12th grade now?
Yes.
Okay. There's going to come a point in time when you're going to have to read some paperwork. Can you assure me that if you're having any difficulty understanding what you're reading, you'll ask for help, you'll ask your lawyer, you'll ask for me, but you'll ask for assistance to make sure you understand it?
Yes.
All right. Are you a U.S. citizen?
Yes.
Now, before you came into court here this morning, have you any drugs or alcohol of any kind?
No.
Your eyes are rolling up into your head. It seems like you're thinking about something there.
No.
When's the last time you had anything?
No.
You've had anything within the last 48 hours?
Mm-mm.
You need to answer out loud so the judge can hear you, Trayvon.
Any drugs or alcohol in the last 48 hours, past 2 days?
Yes.
What was that?
So,
What was it?
marijuana.
When did you last have the marijuana?
Should be.
I can't hear you.
Ago. A couple of days ago.
So you had marijuana a couple of days ago. Do you have it today at all?
No.
You currently under the influence of marijuana right now?
What you mean by that? Like,
Are you high?
constantly? I don't know.
I said, are you under the influence right now of marijuana? Like, when's the last time you had it? You said 2 days ago?
Mm-hmm.
Is that the truth?
Yeah.
You have it yesterday?
No.
So are you feeling the effects of marijuana right now?
No.
You need to speak up and be clear. I can't understand what you're saying.
No.
No.
I feel calm.
Okay. Feel calm because of marijuana, or you just feel calm normally?
Just normally.
All right, so you're not feeling the effects of any marijuana right now? Is that a yes or no?
No,
Okay.
I feel normal.
All right. Well, I don't know what normal is for you. I just want to make sure you're not under the influence of marijuana. Because I need to make sure that you're of clear mind right now. You can appreciate your surroundings. You're having no difficulty communicating because of any drugs or alcohol or anything like that. That's not an issue here?
Mm-mm. No.
Any prescribed medications in the last couple of days?
Medications? I don't take medication.
You don't take anything?
No.
Okay. You would have been served with a copy of this indictment sometime back in the beginning of September. Do you remember getting it? It's the document that sets forth the charges.
Yes.
In that indictment, you're charged with 2 counts. The first count is a charge of grand theft of a motor vehicle. What's alleged here is on or about July 20th, 2025 in Lake County, Ohio, that you did with purpose to deprive Albert Sluga, who is the owner of property, that being a motor vehicle, that you knowingly obtained or exerted control over that property without the consent of Albert Sluga, the owner, or anyone else authorized to give consent. Again, the property involved is a motor vehicle, which makes this offense grand theft of a motor vehicle, a felony in the 4th degree. Now, that's what you're charged with. That's not what you're pleading guilty to. That's what you're charged with. Do you understand what you're charged with?
Yes.
Any questions from me about that?
No, sir.
Now, for purposes of the plea today, the state has agreed to amend the indictment to what's called attempted grand theft of a motor vehicle. And what that means is that you engaged in conduct that, if you were successful, would have resulted in the commission of the offense of grand theft of a motor vehicle. And the significance of that for you is that it reduces the charge from a felony of the 4th degree to a felony of the 5th degree, which is less serious. Felonies of the 4th degree, you can be imprisoned up to 18 months in prison, fined up to $5,000. Felonies of the 5th degree carry a lesser penalty. The maximum penalty is 12 months in prison, $2,500 fine. So do you understand the difference between the two?
Yes.
Any questions for me about it?
No, sir.
Now, there is a second count of the indictment that's being dismissed, criminal tools charge. Is that your understanding?
Yes, sir.
Any questions about that charge?
No, sir.
Well, then, before I can accept your guilty plea to this reduced charge in count 1, I need to make sure you understand all the rights you're giving up. And you, first of all, have a right to a trial. Now, a trial could be to me as a judge, where I listen to the evidence and I make that decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. And a jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence that each side wanted to present. The jurors would consider and weigh all that evidence, and then those jurors would make that decision. And that decision reached by the jurors would have to be unanimous. What unanimous means is that they all have to agree together, one way or the other, as to each charge, whether you're guilty or not guilty. So all 12 would have to find you guilty, or all 12 would have to find you not guilty. You understand that?
Mm-hmm. I mean, yes.
Do you understand that by pleading guilty, you're giving up your right to have a trial?
Yes.
Now, if you had a trial, the prosecutor over here would be representing the state of Ohio. He would have what we call the burden of proof. Now, with him having the burden of proof, what that means is that it's his job, or he bears the responsibility or the obligation to prove you guilty at a trial before you could ever be found guilty. You're presumed innocent of these charges. And the presumption of innocence sticks with you and stays with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes.
Now, when I talk about this burden of proof, what that actually is in this case, since this is a criminal case, we call that proof beyond a reasonable doubt. That's the highest burden there is in our justice system. What that means, it's the amount of the evidence or the quality of the evidence the state has presented at trial to prove you guilty. So in this case, since it's a criminal case, the state would have to present evidence to prove each part of that charge I just read to you beyond any reasonable doubt before you could ever be found guilty of this charge. You understand that?
Yes.
To understand by pleading guilty, you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt?
Yes.
Now, in order to do that, or at least in order to try to do that, the prosecutor would bring witnesses into the courtroom to testify for the state by answering questions from the prosecutor. Now, once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same persons questions. That's called cross-examination. Your lawyer could ask him anything he wanted to within certain rules. Do you understand that?
Yes.
Do you understand by pleading guilty or giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
Yes.
Now, you'd also have the right at a trial. You could call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that. But you have a right to do that if you wanted. Do you understand that?
Yes.
And you further can request the court issue an order. We call that order a subpoena. What a subpoena would actually do is it would force or make someone come to court and testify for you and answer your lawyer's questions if they weren't willing to come in voluntarily on their own. Do you understand that?
Yes.
Do you realize you're giving up that right?
Yes.
You have questions about that?
Mm,
I'm sorry?
no.
Okay. Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you have a constitutional right not to testify if you don't want to. That's a decision that you would have to make. Do you understand that?
Yes.
So since that's your decision, what that really means then is that nobody else could force you or make you, nobody could compel you to get up on the stand and answer questions and testify. I can't make you testify. More importantly, the prosecutor, he wouldn't be allowed to call you as a witness and make you get up on the stand and answer his questions. Your own lawyer can't make you testify if you didn't want to. You understand that?
Yes.
Further understand that if we did go to trial and you were found guilty of any of these charges, you would have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding that this court will enter if your plea is accepted, as well as any other issues that you could have raised or brought to my attention up to this day. Do you understand that?
Yes.
All right then, Mr. Crawford, do you have any questions for me about all these rights we've just discussed?
No.
These are all the rights you have and all the rights you give it up by pleading guilty. Understand them all?
Yes.
You still want to plead guilty?
Yes.
Do you understand a guilty plea is a complete admission of guilt? So it means you'll be admitting to the facts being alleged by the prosecutor regarding this lesser charge. We're not going to argue later that you didn't do this or it's someone else's fault or anything like that. Do you understand that?
Yes.
Further, as a result of pleading guilty, the effect of that plea is that you will be found guilty by the court and then you will subsequently, on a future day, be sentenced by the court. Do you understand that?
Yes.
Now, as far as sentencing goes, you're pleading guilty to a felony of the 5th degree. This felony of the 5th degree is punishable by a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. Do you understand that?
Yes.
Now, are you currently on probation or parole or supervision to any other courts or agencies?
No.
Do you have any other charges pending against you anywhere?
No.
If a prison sentence is imposed in this case upon your release from prison, you could be placed in what's called post-release control. We sometimes call that parole. That's a period of supervision you would be on after you served and completed the prison sentence. And in this case, it's not mandatory. It's up to the parole authority to decide that, but it could be up to 2 years. Do you understand that?
Yes.
And if you were on post-release control at any point and you ever violated any of the conditions of your supervision, the parole authority could send you back to prison as punishment for violating the rules for another 9 months for each separate parole violation you committed, up to a total maximum of 50% or half of whatever the term was imposed by the court. Do you understand that?
Yes.
Now, aside from the possible prison sentence, there are other penalties or sanctions the court could order. I could fine you, as I alluded to earlier. The fine for the charge you're pleading guilty to is up to $2,500. It's not mandatory, but I could fine you up to that amount. Do you understand that?
Yes.
Could also order that you pay court costs or reimburse the county for any cost of confinement, community supervision, or treatment, if any of that were applicable. Do you understand that?
Yes.
And you said restitution is not an issue, correct?
That's correct, Your Honor.
Now, a few moments ago, Mr. Crawford, I explained to you the possible prison sentence. When I was doing that, I used the word possible. Prison's not mandatory with this charge. You're eligible for probation or what we call community control sanctions. Do you understand that?
Wait, what?
You're eligible to be put on probation, but it's the formal term for probation is called community control sanctions. That's also referred to as probation. It's an alternative to prison, so you don't have to be sent to prison in this case. A mandatory prison sentence is not required. you could be put on what's called probation. You understand that?
Yes.
And you know what probation is? Have an idea about it?
Yes.
It's a period of supervision you would be on to the court for a period of years. It could be up to 5 years. And the court would order certain conditions and rules for you to follow. There are certain rules of probation. You'd have a probation officer that you'd have to meet with, and you'd have to comply with the rules of probation, the conditions of the court. You understand that? If you're
Yes.
put on probation, that's what it would be entailed.
Yes.
Now, one of the conditions of your probation could be that you serve a term in the Lake County Jail of up to 6 months. So just because you get probation, that doesn't automatically mean there's no jail time. That means there's no prison, but there could be jail. There's a difference between prison and jail. Jail is right next door here in the Lake County Jail. Prison is the state system. So if you're put on probation, you can still go to jail in Lake County Jail for up to 6 months. It's not required or mandatory, but that's a possibility. Do you understand that?
Yes.
And if you are put on probation to this court and you ever violate any of the rules or conditions of your probation, we would have a hearing here in court to see if you're what's called a probation violator. If it was determined that you were, I could extend your probation up to 5 years if it wasn't initially 5 years. I could impose more restrictive sanctions against you. That could include an order that you serve time in jail. Or I could terminate your probation and send you to prison. If I did that at that point, again, it could be 6 to 12 months in prison, and that could be consecutive or in addition to any other prison sentence you may be serving at that time if some new offense occurs, or that you're being sentenced to at that time for some new offense. Do you understand that?
Yes.
Lastly, when we get to the sentencing hearing on another day, you're going to have the right on that day to say anything you want. You can let anything you want me to know or consider. You don't have to, but you have a right to speak. Your lawyer could speak on your behalf. He's allowed to recommend a sentence to the court. Prosecutor can also recommend a sentence to the court. Do you understand that?
Yes.
Do you understand that whatever anyone says at sentencing regarding what they think should happen and what the sentence should be, it is just what I just said. It's a recommendation. I don't have to go along with that if I didn't think that's the right thing to do. Do you understand that?
Yes.
All right, well, do you have any questions at all regarding the potential penalties you face by pleading guilty?
No, sir.
You understand all the possible consequences?
Yes.
Do you still want to plead guilty?
Yes.
Have you had enough time to talk about this case with your lawyer and have him review everything with you, go over the reports, answer your questions?
Can we get more time, please?
I'm sorry?
Can we have more time, please?
You want more time?
Or no?
You're asking for more time? You need to talk to him right now? You want to talk to him? Go ahead. Or let me put some, hang on. So have you had enough time to speak with him before entering this plea?
Yes.
Has he or anyone else made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty here?
No promises.
Have you been threatened or coerced in any way to plead guilty?
No.
So are you entering this plea voluntarily, freely?
Yes.
All right, do you have any questions for me at this point regarding anything we've just talked about? The rights you're giving up, penalties you face, any what you're pleading guilty to? Any questions for me?
No, sir.
You need any more time to speak to Mr. Matthews?
No.
Okay. Then what's going to happen at this point, the prosecutor here next to you is going to explain for the court what the facts would be regarding this case if we had a trial. I want you to listen to him because then I'm going to have some follow-up questions for you about that, all right?
Okay.
All right. Mr. Shapiro?
Thank you, Your Honor. The evidence would show July 20th, 2025, that the defendant, Tremont Crawford, entered the parking lot of a business on Twin Brook Drive called Alba Construction. It's about 3:20 in the morning. The business was closed. Parked in the parking lot was a Jeep Cherokee that's owned by Mr. Albert Slugo. That vehicle was unlocked. The key fob that goes to that car was inside the car. The defendant opened the driver's side door, got in, started the car, and then backed the car up, drove it out of the driveway onto Twin Brook Drive where the vehicle stopped. For about a minute or two, cars just stopped. Police officers were investigating in the area a call regarding a number of males in the classic auto campus lots going through cars. One of the officers comes upon the defendant sitting behind the driver's seat of this car, and through the course of the investigation, arrests the defendant. He's the only person there. Mr. Sluga does not know the defendant. He had no permission to have this car or to drive it at all. The officers just backed the car up and parked it in the parking lot.
Thank you. Mr. Crawford, were you able to hear what the prosecutor just had to say regarding what he believes the facts would show if we had a trial?
Yes.
What, if anything, do you have to say about those facts as he presented them? Are they true? Did you do what he said?
Yes.
Very well, then, regarding the reduced or lesser charge of count 1 being attempted grand theft of a motor vehicle, felony to 5th degree, what is your plea at this time?
Guilty.
All right, I have in my possession here a 4-page document. This is the paperwork I was talking about earlier with you. It's called a written plea of guilty and judgment entry. It explains everything I've just gone over with you. Before I can accept your plea, I need to make sure you understand this document and that you sign it here in open court. Now, my understanding is that before I came out here, you did have a chance to go over this paperwork with Mr. Matthews. Is that correct?
Yes.
Mr. Matthews, is that accurate? Did you read this over with? Did you read this to Mr. Crawford?
Yes, Your Honor.
Answered any questions he had?
I did.
Did he indicate an understanding of it to you?
He did, Your Honor.
Is that correct, Mr. Crawford?
Yes.
So Mr. Matthews read this to you and you understood what he was telling you?
Yes.
You understand what it says? You
Yes.
have any questions for me about it?
No.
It also appears that you signed it. It says T.C. That's your signature?
Yes.
Okay, and then you did that on this paper?
Yes.
And Mr. Matthews, you witnessed that?
Yes, Your Honor.
Mr. Shapiro, you as well?
I did, Your Honor, and if I may, I neglected to mention that the officer found that the parking brake was on that car. That's why it wasn't moved. I just wanted to throw that out there. But I did see the defendant sign that form, yes, Judge.
Very well, then at this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his lawyer advised of all his constitutional rights and made a knowing, intelligent, voluntary waiver of those rights. The court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea, find the defendant guilty of the lesser included offense of count 1 being attempted grand theft of a motor vehicle, a felony of the 5th degree in violation of 29-2302 and 29-13.02A1. Count 2 will get dismissed at sentencing, but sentencing will be deferred. Going over a pre-sentence report and investigation, drug and alcohol evaluation, and a victim impact statement. Bond's continued at this point. So what all this means, Mr. Crawford, at this point I'm continuing your bond. One of the conditions of your bond is that you don't use drugs and you don't use marijuana. You're going to have to submit urine screens to the probation department. If they should come back positive, your bond would be revoked and a warrant would be issued for you. Do you understand that?
Yes.
Not to use marijuana when you're in. That's one of the conditions of your bond. You were in jail, you got an OR bond released, and you get out and you start smoking weed. Right in violation. And the reason you're out is because the judge reduces this bond and you go and violate the conditions of bond like that. You just don't care what the judge says?
That's not true. I do care what the judge says.
Why are you doing that?
Your
liberty is dependent on, your freedom is dependent on not smoking. And you went ahead and did it anyway.
Bad decision making.
Sorry?
Bad decision making. At the wrong moment.
Now, the purpose of this report that I've ordered is to learn more about you before sentencing. The way the probation department is going to get this information, they're going to conduct an interview with you. It's important that when you meet with them, you're open and honest with them because they're going to check and verify what you tell them. If they learn you're misleading them, they're going to let me know, and I would consider that sentencing. You understand that?
Mm-hmm. I mean, yes.
Also, this is important, you're going to, in order for me to consider probation as an option, that pre-sentence report has to be completed. And for that report to be completed, the interview with you has to take place. So it's important you show up on time when scheduled for your interview. Because if you don't show up, then probation can't conduct the interview with you. And if they can't conduct an interview, they can't prepare a report. And without a report, the law doesn't even allow me to consider probation as an option. And I won't continue the sentencing to another day to get that interview done and the report done because it wasn't done initially because you didn't show up. You understand that? I can repeat
Wait,
that.
when was this?
Huh?
This already happened?
No. He's saying.
No, I'm saying at this point, you're going to leave here right now. You're going to go to the probation department. You're going to fill out some paperwork, and they're going to give you a day to come back for your interview with them because they have to conduct an interview with you. All right?
Okay.
They have to do that interview in order for them to be able to do a report. If they can't conduct an interview with you, they can't conduct a report. The interview is going to be scheduled in the future.
Okay.
So what I'm saying is that if you don't show up, they can't do a report, and then I'm not allowed to consider probation as an option. So it's very important you show up when you're supposed to show up.
All right.
All right? And then what I'm saying is that if you don't show up, I'm not going to continue the sentencing to another day to give you more time to get this interview and report done because it wasn't done initially when you didn't show up when you were supposed to. You understand that?
Yes, sir.
All right, so again, you're going to leave here now, go to the probation department. Make sure you go right there from here. Your lawyer will show you where that is. Shapiro, anything else?
No, Your Honor, thank you.
Mr. Matthews?
No, Your Honor, thank you.
We're before the court this morning in two cases, both captioned State of Ohio versus Jeffrey Alvarez. Case number 25-CR-586, also case number 25-CR-1353. The defendant is present in the courtroom with his attorney, Mandy Gwertz. We're before the court this morning for purposes of a plea on 25-CR-586, for purposes of a plea by way of information on 25-CR-1353, and also with a request to proceed straight to sentencing today, this morning, on both of these cases as well, Your Honor. In this request and these pleas are forthcoming in accordance with the plea agreement that's been reached between the parties. The pleas the court will put the terms of the agreement on the record.
Please.
Pursuant to the agreement, the defendant will plead guilty to count 2 in case number 586. That is a felony of the 5th degree aggravated possession of drugs count, methamphetamine. Also the attached forfeiture specification for the drugs in a glass pipe. The defendant will also waive his right to have this matter presented to the grand jury and plead guilty to the information filed in case number 1353, that being 1 count felony of the 5th degree ag possession of drugs with a forfeiture specification for the drugs, again methamphetamine. Upon the condition of those guilty pleas being forthcoming, accepted at the court after findings of guilt, it's my understanding, pursuant to the agreement, the defendant will waive his right to have a pre-sentence report prepared. The parties would then present a joint recommendation for a term of imprisonment of 10 months on each of these cases concurrent, Your Honor. Thank you.
Thank you. Ms. Gwertz, does that sound accurate?
Yes, Your Honor, that is my understanding of the plea agreement that I've also gone over with my client. That's his understanding as well.
Thank you. Mr. Alvarez, were you able to hear what the prosecutor and your lawyer just had to say regarding what they believe your intentions are here this morning?
Yes, sir.
They indicated to the court they believe it's your desire in the original case, the first case, to withdraw your previously entered plea of not guilty and plead guilty to count 2. Count 1 would get dismissed. In the newer case, you would waive your right to have that case presented to a grand jury, and I'm going to explain to you in a moment what that means in more detail. Then you plead guilty to the 1 count in that information. We would then, you're then going to waive the preparation of a pre-sentence report and request to proceed straight to sentencing, where there will be a joint recommendation or agreed recommendations between the parties that 10-month prison term on each case be imposed, that those terms run concurrent with each other. Is that your understanding of the discussions that took place between your lawyer and the prosecutor and what you want to do today?
Yes, sir.
Well, before I can accept your plea, I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you had that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine all those issues, I'm going to ask you a series of questions. If at any point when I'm asking you the questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to speak with your lawyer to ask her questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes, sir.
All right. Let's get started then. How old are you, sir?
I'm 39 years old.
Are you able to read and write the English language?
Yes, sir, I am.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No, sir.
Are you a U.S. citizen?
Yes, sir, I am.
Now, before you came into court here this morning, have you any drugs or alcohol of any kind?
No, sir.
What about in the last 48 hours?
No, sir.
Not even prescribed medication?
No,
Nothing?
sir.
Let's start with the more recent case. Did you receive a copy of the information in that case? That's the document that sets forth the charge you're pleading guilty to?
I believe so, Your Honor, yes, sir.
Did he get to see that, Ms. Gwertz?
I'm not entirely sure. I don't think he
You don't have
actually
it?
has. I don't have a copy of it printed right at this second.
Handing Ms. Gwertz a copy of the information, Your Honor.
This is the information. Sorry about that, Your Honor.
Let's take a look at that real quick, Mr. Alvarez.
Yes. I thought it was in like July or June or something. Did I get pulled on anything? First one was in March. I could be.
August would be right.
Okay. Okay, yes.
Use custody for date.
Okay.
So you've had a chance to look that over, Mr. Alvarez?
Yes, sir.
So in that information, you are charged with one count. And what's alleged in that count is that on or about August 18th, 2025, in Mentor Lake County, Ohio, that you did knowingly obtain, possess, or use methamphetamine or some compound mixture, preparation, or substance containing methamphetamine. Methamphetamine is a Schedule II controlled substance. The amount involved did not equal or exceed the bulk amount, which makes the offense aggravated possession of drugs, a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in this information in count one?
Yes, sir.
Any questions for me?
No, sir.
The charge also carries with it what we call a forfeiture specification, which alleges that during the offense you possessed or had an interest in property considered to be contraband. Contraband is property that's illegal just by the nature of the property, like drugs. And in this case, it's the methamphetamine. And the whole point is so that the state can dispose of it. You forfeit your ownership interest in it. It doesn't increase any possible penalty you face. It just gives them the right to be able to dispose of it later.
No, sir.
Any questions about that?
No, sir.
Okay. So you understand the nature of the charge you're pleading guilty to in this case?
Yes, sir, I do.
Now, in the other case, the first case, 25 CR 586, you're charged with 2 counts. This occurred back in March of this year. You're pleading guilty to count 2. In count 2, what's alleged here is on or about March 26, 2025 in Lake County, Ohio. Again, that you did knowingly obtain, possess, or use methamphetamine or some compound mixture, preparation, or substance containing methamphetamine, Schedule II controlled substance. It did not equal or exceed the bulk amount, which makes the offense aggravated possession of drugs a felony of the 5th degree. This charge also carries a forfeiture specification, which is the methamphetamine, again, along with this one, a glass pipe.
Yes, sir.
Any questions about that?
No, sir.
You understand the nature of this charge?
Yes, sir.
Now, there is another count in this indictment, count 1, that's being dismissed pursuant to the agreement. Is that your understanding?
Yes, sir.
Any questions about that charge?
No, sir.
Well, then, before I can accept your guilty plea, I need to make sure you understand all the rights you're giving up by pleading guilty. And again, we're going to go first with the newer case that you have. In that case, you're charged by way of an information. That's the document that you just read that your lawyer showed you. An information is a criminal charge brought by the prosecutor's office without the case having been reviewed or considered by a grand jury. Now, what a grand jury is made up of a group of citizens here from Lake County that get together and they meet privately. They meet in secret for the purpose of evaluating evidence in cases to determine whether probable cause exists that someone committed a crime. Probable cause is defined as some evidence that would suggest the person probably committed a criminal offense. Now, everybody here in the state of Ohio accused of a felony has the right to have a grand jury independently review the evidence in a case and make a decision without the government being involved in that decision, whether someone should be charged or not. That's what happened in the other case. They went to the grand jury reviewed it and made a determination. That hasn't happened in this case. But you have the right to have that happen, but you can also waive that if you want and go forward on the charge brought by the prosecutor. And your lawyer has indicated she believes, based on her discussions with you, that that's what you want to do. Is that correct?
Yes, sir, it is.
Well, before I'm permitted to go any further in this case on the information, I need to have you acknowledge that here in open court in writing, and I'm going to hand you at this time, I have in my hand at this time a one-page document called a waiver of indictment, which sets forth everything I've just talked about with this grand jury proceedings. Before I can go further, I need to make sure you understand the document that you signed it here in court. Now, my understanding is you had a chance to review that document with Ms. Squirts before I came out here. Is that correct?
Yes, sir, it is.
Ms. Squirts, is that accurate? Did you read this over with your client, review it with him, answer his questions?
I did, Your Honor.
Did he indicate an understanding of it to you when you did that?
He did, Your Honor.
Is that correct, Mr. Alvarez?
Yes, sir, it is.
You understand what the document says?
Yes, sir, it is.
Any questions for me about it?
No, sir.
Now, it also appears you signed the document. Did you sign it?
I did, sir.
And you witnessed that, Ms. Squirts?
Yes, I did, Your Honor.
Mr. DePiro, you too?
Yes, Your Honor.
All right, so that document, the waiver of indictment, will be made part of the record in this case. At this point, Mr. Alvarez, I'm going to review with you all the other rights you have, and they apply to both cases. I'm only going to go through them one time, but I need to make sure you understand it applies to both cases. If there's something that applies to one case and not the other, I'll make sure I point that out. I don't think that's the case, but if it did, I'll let you know that. But otherwise, everything applies to both cases. And in that regard, in both cases, you have a right to a trial. And a trial could be to me as a judge, where I listen to all the evidence, and then I make that decision whether you're guilty or not guilty of the charges. But in each case, you also have a constitutional right to a jury trial, and that would be in front of 12 citizens here from Lake County who would listen to all the evidence that each side wanted to present. Those jurors would consider and weigh all that evidence, and then those 12 jurors would make that ultimate decision. And that ultimate decision reached by those 12 jurors would have to be unanimous. That means all 12 jurors would have to agree together, one way or the other, whether you were guilty or not guilty of each separate charge. You understand that?
Yes, sir, I do.
Do you understand by pleading guilty you're giving up your right to have a jury trial in each of these cases?
Yes, sir.
Now, if you did have a trial, you'd have the right to have an attorney represent you at trial. If you could not afford an attorney, the court would appoint one for you free of charge to represent you at trial. Do you understand that?
Yes, sir.
Now, at a trial, the prosecutor here would represent the state of Ohio. He would have what we refer to as the burden of proof. And what the burden of proof means is that it's his job, or he bears the responsibility or obligation, he bears the burden to prove you guilty at a trial before you can be found guilty. You're presumed innocent of the charges, and the presumption of innocence remains with you and stays with you until the state, if at all, was ever able at a trial to overcome that presumption of innocence and prove you guilty. Do you understand that?
Yes, sir.
Now, when I speak about this burden of proof, since this is a criminal case, the burden of proof is what we refer to as proof beyond a reasonable doubt. And that is the highest burden there is in our justice system. And what it actually means, it's the amount of the evidence and the quality of that evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of the charge beyond any reasonable doubt before you could ever be found guilty of the charge. You understand that?
Yes, sir.
You understand that by pleading guilty, you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt at a trial?
Yes, sir, I do.
Now, in order to do that, or at least in order to try to do that at a trial, if we had a trial, the prosecutor would be bringing witnesses to the courtroom to testify for the state, and they'd be answering questions from the prosecutor. Once those witnesses answer the prosecutor's questions, then your lawyer would have the right for you on your behalf to ask those same person's questions. That's called cross-examination. She could ask him anything she wanted to within certain rules. Do you understand that?
Yes.
Do you understand by pleading guilty you're giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
Yes, sir, I do.
Now, you'd also have the right at a trial. You could call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that, but you have a right to do that if you want. Do you understand that?
Yes, sir.
And you further can request the court issue an order. We call that order a subpoena. And what a subpoena would actually do is it would force or make someone come to court to testify for you and answer your lawyer's questions if the people weren't willing to come in voluntarily on their own. Do you understand that?
Yes, sir.
Do you realize you're giving up that right?
Yes, sir, I do.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes, sir.
And since that's your choice, what that really means then is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But more importantly, the prosecutor here, he's not allowed to call you as a witness and put you up in the stand and make you answer questions and testify. Your own lawyer can't make you testify if you don't want to. Do you understand that?
Yes, I do.
You further understand that if we went to trial and you were found guilty of any of these charges, you would have the right to appeal or challenge those guilty findings to a higher court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention at this time. And that includes, there was a suppression motion filed in the first case, where your lawyer, what a suppression motion is, it's a motion that she made on your behalf, arguing that law enforcement in that case violated certain constitutional rights that you have, and because of that, any evidence that was discovered as a result of that violation should not be allowed to be used against you at a trial. She made that argument in a motion. We were scheduled for a hearing. We didn't go forward because of the new charge that came forward, and you're withdrawing that motion if the court accepts the plea.
That is correct, Your Honor, we would withdraw.
So I just want to make sure you understand that that's an issue that's not going to be addressed, and you give up your right to address it at any point down the road. You understand that?
Yes, sir, I do.
All right, well, do you have any questions for me at all regarding these rights we've just discussed? These are all the rights you have and all the rights you're given up by pleading guilty. Any questions?
No, sir, I do not.
Do you understand them all?
Yes, sir, I do.
Do you still want to plead guilty?
Yes, sir, I do.
Do you understand a guilty plea is a complete admission of guilt? It means you're admitting to the facts being alleged by the prosecutor. What that also means is we're not going to argue later that you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes, sir.
Further, as a result of pleading guilty, the effect of that plea is that you'll first off be sentenced by you'll first of all be found guilty by the court, and then you will subsequently be sentenced by the court. Do you understand that?
Yes, sir.
Now, as far as possible penalties go, in each case, you're pleading to one count, and each of those are felonies of the fifth degree. Each of these felonies of the fifth degree are punishable by a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. Do you understand that?
Yes, sir.
Now, since there are two separate, unrelated cases here, if I impose a prison sentence on each case, as a judge, I would have the discretion to run those prison terms concurrent or consecutive to each other. Concurrent means together at the same time. Consecutive means one after the other. So if it was consecutive, you'd serve the prison term in the first case, whatever it was, and it could be different from the second case, or it could be the same, but whatever it was, you'd finish that, then you'd serve the prison term in the next case. You understand the difference there?
Yes, sir, I do.
So with both of these cases, if I give you the maximum sentence of 12 months and ran them consecutive, both cases together, you're looking at possibly 24 months in prison. Do you understand that?
Yes, sir.
Now, do you have any other charges pending against you in any other courts right now?
No.
You have the warrant from Florida.
Yeah, I mean, I do have,
Warrant in Florida, I was advised of that.
yes, sir.
Okay. And that's going to be irrelevant. The only reason I normally ask that is if you're sent to prison and you have another case, that if you were sentenced on another case before I was sentencing you, I could run my sentence consecutive to that, but that's obviously not going to be happening here.
Right.
So,
Yes, sir, thank you.
are you on probation or parole or post-release control to any of the courts or agencies right now?
Besides Florida?
Yeah, sounds like Florida. Is it for a new charge?
No. So it's just a misdemeanor for...
That you were on probation for?
Yeah,
Okay.
yeah.
Well, let me advise you of this at least. I don't know how Florida works, but when you're on probation or parole and you commit a new crime, there could be consequences with the court that you're on probation to for committing a new crime while on probation. Nothing I can do about it. There's no consequences I'm going to impose for that, but there could be consequences with the Florida court as a result of that. You understand that?
Right, sir, yes, sir. Yes, sir.
Now, for prison sentences imposed in this case, upon your release from prison, you could be placed on what's called post-release control. We sometimes call that parole. That's a period of supervision you could be placed on after you complete the prison sentence. It's not mandatory with either of these cases. It's up to the parole authority to decide that, but it could be for up to 2 years. Do you understand that?
Yes, sir, I do.
And if you are placed on post-release control for either of these cases and you ever violated any of their conditions or rules of supervision, they could return you to prison as punishment for not following their rules for another 9 months for each separate violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Yes, sir, I do.
Now, aside from the possible prison sentence I just explained, there's other sanctions that could be ordered. You could be fined in both of these cases. Each case carries with it a possible maximum fine of $2,500, which, with both cases together, it's $5,000, possible maximum fine. I could suspend your driver's license up to 5 years. I could order that you pay court costs or reimburse the county for any cost of confinement, community supervision, or treatment if any of that were applicable. Do you understand that?
Yes, sir, I do.
Also, any ownership interest you have in that contraband that I explained before, the drugs and the pipe will be forfeited to the state of Ohio. Do you understand that?
Yes, sir, I wouldn't want that back anyway. Thank you.
Now, a few moments ago, I explained the possible prison sentence you face. I use the word possible because prison's not mandatory within either of these cases. You are technically eligible for probation or what's called community control sanctions. Do you understand that?
Yes, sir.
Now, in order to be granted probation or put on probation, a pre-sentence investigation would have to be completed. That's a report that the probation department puts together for my benefit to let me learn more about you. But it's a prerequisite or required before probation can be granted. In this case, you're waiving the preparation of a pre-sentence report, which means you're not requesting a pre-sentence report be prepared. Is that correct?
Yes, sir.
So do you understand that without that pre-sentence report, then even though these offenses are probationable, I will not be able to consider probation as an option and I'll have to impose a prison sentence? You understand that?
Yes, sir, I do.
Lastly, when we do proceed to sentencing, you'll have the right at that time to say anything you want me to know or consider. Your lawyer can speak on your behalf. She's allowed to recommend the sentence to the court. The prosecutor can also recommend the sentence to the court. Do you understand that?
Yes, sir, I do.
Do you understand that whatever anyone says at sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I'm not obligated to go along and follow that if I didn't think that's the right thing to do. Do you understand that?
Yes, sir.
All right, then. Well, do you have any questions for me regarding the potential penalties you face by pleading guilty?
No, sir.
You understand all the possible consequences?
Yes, sir, I
Do
do.
you still want to plead guilty?
Yes, sir, I do.
Have you had enough time to talk about this case with your lawyer and have her go over everything with you and answer your questions?
Yes, sir.
Are you satisfied with her advice and counsel?
Yes, sir, I am.
Has she, or has anyone for that matter, made any promises to you about what's going to happen at sentencing which is inducing you to plead guilty?
No promise, nothing.
Have you been threatened or coerced in any way to plead guilty?
No, sir, I have not.
Are you entering your guilty plea freely and voluntarily?
Yes, sir.
All right, then, Mr. Alvarez, any questions from me at this time regarding anything we've just talked about? What you're pleading guilty to, the rights you're giving up, penalties you face, any questions at all?
No, sir.
Do you need any more time to speak with your lawyer before we go forward with your actual plea of guilty?
No.
All right, then what's going to happen at this point, the prosecutor here is going to explain for me what he believes the facts would show with each of these cases. We'll do one case at a time. I want you to listen to him because then I'm going to have some follow-up questions for you, all right?
Okay, yes, sir.
So let's start with the first case and we'll do the next case.
Yes, Judge. Chronologically, 586, that was March 26, 2025 in Mentor Lake County, Ohio. The defendant was driving a car, had an interaction with the police officer, and was found to possess inside the car a baggie with 1.75 grams of meth, Schedule II controlled substance, also a glass pipe that had meth residue on it, confirmed by the crime lab.
Mr. Alvarez, were you able to hear what the prosecutor had to say regarding what he believes the facts would show in this case? I'm sorry. If we did have a trial?
Yes, sir.
What, if anything, do you have to say about those facts as he presented them? Are they true? Did you do what he said?
Yes, sir.
Very well, then, regarding the first case is regarding count 2, charging you with aggravated possession of drugs, being methamphetamine, Schedule II controlled substance, a felony in the 5th degree. With the forfeiture specification, what is your plea to that at this time?
It's guilty, Your Honor.
All right. Mr. DePiero, let's go with the other case, 1353, please.
Yes, Your Honor. The evidence would show August 18, 2025 in the city of Mentor Lake County, Ohio. Again, the defendant was operating a motor vehicle and with an interaction with a Mentor police officer at that time. He was found to be in possession of 3 baggies of methamphetamine, a Schedule II controlled substance, less than 5 grams.
Mr. Alvarez, were you able to hear what the prosecutor had to say regarding what he believes the facts would show in this case?
Yes, sir.
And what, if anything, did he say about those facts? Are those facts accurate as well? Did you do what he said?
Yes, sir.
Therefore, in regards to case 25 CR 1353, the information in count 1, charging with aggravated possession of drugs, a felony in the 5th degree, Is there a forfeiture specification in this one too?
On the information, Your Honor, there's a...
Yeah, it's not in the change of plea form.
Oh,
So in regards to count one, charging with aggravated possession of drugs applying to the 5th degree with the forfeiture specification, what is your plea to that?
Is guilty, Your Honor.
All right, I have in my possession at this time 2 documents. They're both pretty much identical, one for each case. It's called a written plea of guilty and judgment entry, and it explains and sets forth everything we've just discussed. Before I can accept your plea, I need to make sure you understand what these documents say and that you signed them here in open court. Now, my understanding, once again, is that you had a chance to review these documents also with your lawyer before I came out here. Is that right?
Yes, sir, it is.
Again, Ms. Squirts, is that correct? Did you review both of these with Mr. Alvidrez, read them over with him, answer his questions?
I did, Your Honor.
And did he indicate an understanding of them both to you?
He did, Your Honor.
Is that correct, sir?
Yes, sir.
You understand what they both say?
Yes, sir.
Any questions for me about either of them?
No, sir.
And did you in fact sign it? It appears you signed them. Did you sign both of these documents?
I did sign them, sir.
Ms. Squirts, you witnessed both of those signatures?
I did.
Mr. Caprio, you too?
yes, Your Honor.
Very well, then at this time the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his lawyer advised of all his constitutional rights and made a knowing, intelligent, voluntary waiver of those rights. The court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea, find the defendant guilty of count 2 in case 25 CR 586, as well as count 1 in case 25 CR 1353 of the offense of aggravated possession of drugs, each felonies of the 5th degree, each in violation of 29 and 2511 of the revised code, and each with a forfeiture specification. In case 586, I'll dismiss count 1 at this time. And in that case, Ms. Squirts, then you are withdrawing the motion to suppress?
I am, Your Honor.
And that will be withdrawn. And Ms. Squirts, then, in regards to both of these cases, is there any reason not to go forward with sentencing at this time?
No, Your Honor.
So it was indicated during the plea, I just want to reaffirm that now, your client's waiving a pre-sentence report in each of these cases?
That is correct.
Is that correct, Mr. Alvarez? So you know, again, I can't consider probation as an option then, you understand that?
Yes, sir, I do.
All right, then, Ms. Squirts, anything you'd like to say on behalf of your client?
Your Honor, as outlined, the joint recommendation for sentencing, we would ask the court to go along with that, 10 months on each case concurrent. My client, obviously, he's been to prison before. He has gone to prison for drugs before. This, again, is a drug issue. He and I have had lengthy conversations about this. It's very unfortunate because, you know, by all outside accounts, he was functioning. He was working over 40 hours a week for Omni Systems in Mayfield. He has a strong family support, and his family is sober. So he is able to function. He had his driver's license back. He did have a suspension here on that second case, but he was able to get his license valid within a couple of days. So he is somebody who is able to function and get through things. We've had lengthy conversations. He's very disappointed in himself because he was in a good spot in his life, but he continued to use drugs. And when he continues to use drugs, he finds himself in situations like this, that he's now back in front of this court looking to go to prison again. I know that remorse isn't necessarily always a factor in drug cases, but he has certainly been very remorseful for the situation he's put himself in, he's put his family in. You know, despite the fact that he was doing well in life, he continued to set himself up for failure to be here in front of you again, and I know he has a lot of regret about that, and he understands from speaking with him that he's at a point in life where there just can't be any exceptions. He can't casually use, he can't in any way do that, or he's going to find himself back here again. So we'd ask the court to go along with the joint recommendation.
Thank you. Mr. Alvarez, you do have the right to address the court before your sentence. You can say anything you want. Is there anything you'd like to say at this time?
Only that everything my attorney stated is true. You know, I am very ashamed of my actions and everything I've done, and I do want better for myself, and I know I'm capable of better, and I apologize. That's also.
This court, anything else?
No, Your Honor.
Should appear for the state.
The state will join in the recommendation of 10 months in prison on each case to run concurrent with each other. The court is aware the defendant has been to prison on 3 prior occasions in 2010, 2019, most recently in 2023. The defendant does have credit for 39 days already served in case number 586 and for 2 days already served in case number 1353. Ask for forfeiture of the contraband. Thank you.
Well, this court has considered the facts and circumstances as they were laid out for the court during the plea of each of these cases. I've considered what's been said by the attorneys, the defendant, joint recommendation, nature of the offenses involved. All this is considered in light of the purposes and principles of felony sentencing set forth in 29-29-11. So the factors in 29-29-12, nothing stands out factually in regards to either of these cases that make it more or less serious than the normal possession charge we deal with. As for recidivism factors, the court finds the defendant does have a history of criminal convictions. That in case 25 CR 1353, he committed the offense while on bond. In case 25 CR 586, committed both cases while on bond in a case out of Florida, or it was a warrant out for him, correct?
Yes.
He's on probation. He's on probation. That's what it should be for a case in Florida. He has not responded in the past favorably to previously imposed sanctions ordered by the court. It's a drug abuse problem that relates to the offense, and he hasn't done anything at this point to address that. Hopefully you do. I will find genuine remorse under the factors indicating less serious, less recidivism. Under 29-29-13B1, court notes defendants previously served prison terms that overrides the presumption for community control. Prison's consistent in each of these cases with the purposes and principles of sentencing, and the defendant is not amenable to available community control sanctions. Therefore, in case 25 CR 1353, the sentence of the court defendant served a term in prison of 10 months. He has credit for 2 days in that case. Case 25 CR 586 is the sentence of the court defendant served a term in prison of 10 months. There's credit for 39 days in that case. I'll run the 2 prison terms concurrent with each other for an overall prison term of 10 months. I need to advise you upon your release from prison, as I told you a little bit ago, you could be placed on post-release control. It's up to the parole authority. If they do that, it could be up to 2 years. And if you're on post-release control and you violate any of their conditions, they could return you to prison as punishment for violating the rules for another, with these cases, 5 months, the maximum being 50% of the prison term I just imposed. Any additional prison term imposed for violating post-release controls being imposed as a part of the sentence at this time. Defendants ordered to pay all costs. I will release bond. I'm not going to forfeit any bond that was posted. I think that's it. Did I forget anything, Mr.
Just forfeit the drugs. And
Oh,
the like.
I knew there's something. I'm going to forfeit the contraband and instrumentalities in each of the 2 cases. Thank you.
Thanks.
Ms. Kurtz, anything else?
No, Your Honor.
All right. Good luck, Mr. Alvarez.